what my eyes dare to see, or the greatness I possess, endless possibilities. Look in the mirror, what do I see?
Welcome to another segment of Seek Elevation with yours truly, attorney Ella-Keisha. Yes, I am an attorney, but I may not be yours. And being that I'm not giving you legal advice when I talk about legal topics, and I will do that with our current topic, the NIL era in college sports. This is a 4-part series on that. But I'm not giving you legal advice. I am giving you very pertinent, important, vital legal information that can help you in this space. But right now, you are just tuning into the Seek Elevation experience. This is where real issues and real people and real conversations take center stage, because we know, and I keep saying it, change doesn't happen in silence. And we have conversations from sports and entertainment to business and community, and we elevate voices that need to be heard. But we don't just talk here. We empower, we inspire, and we challenge the status quo. And I always challenge you to connect. The more you connect, the more you stack up with the right people that are aligned with you, the more you elevate. So we're going to go ahead and get into today's segment. But again, a little recap. This is episode 3, segment 3 of the 4-part segment, Power Plays, the NIL era in college sports. And we meet up here every Tuesday. We have met up every Tuesday. And we're almost done. We only have one segment after this. We started off with segment 1 and 2. We went from the foundation. We talked about a little bit about the historical aspect of NIL, very important to know. And then we moved to the framing of it. And now we're going to talk about the house that is being built, the house. And there's a pun intended when I say that. So if you are just tuning in right now, just a little bit about me, other than being an attorney, I am a former collegiate athlete, coach, elite athlete. So I get it. I'm speaking from a perspective of I get it. Not only was I a collegiate athlete, but I finished off my collegiate career in a Power 5 school, which is one of the schools that was named as a defendant in the case that we're going to touch on today. So I get it. So in segment 3, I want us to go ahead and step into this tug of war that followed the Alston case between the NCAA, the state, the schools, the conferences, and then of course the federal government was kind of thrown in there. There were people that was begging for them to join their side of the tug of war, and we'll get more into that. But in addition to these entities, then we had the fast growing influence of collectives, and those who understand college sports do already understand the term boosters, right? Like there's booster clubs that will help the institution and be that bridge between athletes and institutions. There's always been some type of issues there, making sure that no one crossed the line when we're talking about boosters, especially when it came to sports such as football. But then you add to that mix these collectives, these businesses that formed, these LLCs that formed, that said, hey, we are the face of these particular colleges, but we're really here to identify and to help with business deals with these athletes, um, be that liaison to land those deals, get them some money, and hopefully get their attention to come to those schools. But let me ask you something before we go further. I want to recap some terms, some vital terms that I said that you should know. And if you don't know them, again, I highly encourage you to go to segment 1 and 2. These segments are built upon each other. If you're going to be in the NIL space, and I'm speaking from a athlete perspective right now, right? One of the things that is extremely frustrating as athletes is to depend on professionals, whatever your profession is, right? Depend on professionals, whether it's attorneys, agents, managers, and you do the thing, your thing. You do your thing. You may know how to negotiate, read contracts. Well, professional may be someone that's helping me with taxes, but you don't understand the life and you're disconnected from that. And this case, you don't understand what's going on in the industry. If we're going to show up, and this is in any industry you're in, if you're going to show up, you have to at least understand the basics of where you're showing up, understand the jargon, understand, just be in the know of what's relevant, what's timely, because you'll be more respected if that happens. And this is a very complex and very dense topic. So I didn't go over everything, but I was giving you enough to know to show up in rooms, whether you're the athlete yourself, parents, coaches, or someone representing athletes, to have enough information to at least show that you're somewhat in the know. If you walk into a room of individuals and they're having a conversation and they mention O'Bannon, do you know how to jump in that conversation? If they say, oh man, that O'Bannon case, could you have imagined we've come this far just from that? If they asked you that question, would you know how to engage? Would you know how to respond? If you were in a room of individuals and they just said Alston, Alston really impacted this NIL era. I wonder how long we would have been going on if it wasn't for Alston, even though it wasn't about getting paid NIL money for athletics. Would you know how to engage in that conversation? Now, what if someone just, you are a group of people, or, you were talking to your athletes, or you were around someone who said, oh, I can't, they find out that you're in the NIL space. They're like, oh, why are you in the NIL space? That's, I just have something against that. These student athletes, why don't they just focus on being in college? That's the perk. That's the benefit. Why are they so pressed on getting this money? That has not been the history of sports in college. I mean, they should just focus on the history. We're here to enjoy sports. The sports help develop the student with these characteristics that probably the general student population don't have. Just appreciate that. I mean, they're amateurs. This is amateurism. They're student athletes. Now, what if someone had that conversation with you? What would you be able to say back and sound knowledgeable in that conversation? If they throw out the terms and spoke in the context of amateurism and being focused on being a student athlete, and the history of sports was founded on that, what would you be able to say? Because one thing you don't want to do is have someone who's not practicing in the space, in the area you're practicing in, come off as if they know more than you know in your area. So I answer you. If you didn't answer those questions in your mind as I asked them, you didn't know how to answer them, then again, go back to review segment 1 and 2. But right now we are, we're in a space where athletes are finally getting what they had long been denied. We're here now, right? So that's not the question anymore. they have their right to participate in the marketplace, but there's so many other questions that have opened up. And a significant part of them getting that right, we know, was because of the Alston case. But when NCAA stepped back after the Alston case, they stepped back to regroup themselves. They stepped back to figure out, what policies do we need to roll out? We need to step back and get it together because we weren't prepared that it was going to fall this way. I mean, I'm not in their head, but if you look at the circumstantial evidence, they weren't prepared for that, right? They had to say, whoa, after the Alston finding, we need to step in here and develop an interim policy. And while they were doing that, there were states already all over it. So when the NCAA stepped back, they didn't hand over. When they stepped back and came back in with an interim policy, they didn't hand over a clear rule book, right? They didn't hand over something. Here's the interim policy, and it's very clear on what needs to be done until we lay out a more permanent thing. And what they did hand out in the interim was something that was to everyone and no one all at the same time. It was very circular. And what do I mean by that? It was a policy that was developed, issued, and when you read the policy, a lot of it would point back to, hey, this is what the NCAA feel, but we defer to your particular institution. Or this is what the NCAA feel, and pay attention to your state laws if you have one. But everyone was doing that. Now the institution was putting policies out. We're putting policies out, and then they'll say this is institutional policy, but pay attention to the NCAA and the state law. State laws were doing that. State laws are saying, here's what we find in the legislation. And we are also respecting and adhering to policies that are laid out. You had some state laws where in the legislation, as far as the effective date, right? It would say, okay, this legislation is effective on this date. And some of them has sunset clauses, like it's going to be effective until this particular time. And Georgia was one of those states. So when our legislation, NIL law came out, it was like, here are the laws. These are the things that I want you to, understand. And some things we're deferring to with the NCAA and institution. However, this law is effective until some type of rules or policies are put into place, either by federal law, anything that's after March 31st, or if it's rules, policies, procedures in general, which did happen technically, right? NCAA came out afterwards. But then the last element was, if 1 and 2 doesn't happen, regardless, this legislation will not be effective. It will be repealed by June 30th, 2025. So no matter what happened, one of those things was going to make our state law ineffective. And so it looked different for each state with that. And so it was very confusing. It was like, okay, for state laws that are still in place with NCAA policy and institution policy, where do we go with that? But then what about the states where we no longer have it, but you have these other things? Do we now ignore what we were possibly following, some of the things we were following for our state law? Do we have recourse on certain things? It was chaotic, very chaotic. And to that, I say, welcome to the decentralized NIL era. That is what that developed. But I always say, this is my mantra and I live by it. Where there's chaos, there's an opportunity. There are opportunities there to be found. When there's a lot of chaos, if you can find the calm in the chaos, the competence in the chaos, then you'll find opportunities. But, there were schools scrambling, juggling how to, one, protect their brand image, putting out different type of policies on that. Compliance departments had headaches, hired new people, did consulting outside of their college as well, because it was a lot. Individuals, there's a lot of lawsuits continuing to happen. And while they were happening, they wanted to make sure that they weren't, violating anyone's rights. And then schools were also just dealing with risks of losing star players, right? We had the transfer portal that we mentioned before, but you had these other institutions. Some were better off than others. Some had put together these great collectives, and people were offering money, throwing things out to the point where they were running afoul to a lot of laws. A lot of them were doing pay for play. I've had conversations and spoken to different people where, they loosely stated, yeah, in that contract, if this is accomplished and this is accomplished, you get that. And I'm like, yeah, no, that's not how it's supposed to go. But a lot of those things were created in contracts, and it was a fine line between endorsement and inducement. And that's how it looked. The Power Five conferences, such as the SEC, the Big Ten, such as those two, they started to create their own NIL guidelines, trying to, fill the vacuum. But a lot of people were just, making what they thought was the best decision, thought they were smart decisions, at least for the most part. But they were doing so without consistent rules or enforcement, really true enforcement of those rules. Because I will say this, and anybody who's in the NIL space, and you don't have to be all the way in it, you can kind of just be looking from the outside in. You can clearly see this, that there were things that you can tell it was evident. It was evident that it was pay for play. So even with some people saying, okay, if we don't know the details of this situation, we can tell that something's not right here. So there were no consistent enforcement of rules, let alone consistent rules. There was truly no training. It was training in real time. And there weren't really resources, even though the NCAA interim policy did state that, there were certain resources that had to be created, especially on the campuses, such as financial literacy and things like that, to try to, adhere to even what some of the state laws were saying. They had to have that in play, but because it was so quick, so spontaneous, it was just a lot of things were just put together and you're learning as you go. But because of that, we hear all the great stories, right? We hear some stories people put out, oh, NIL and such got offered all this great, money or opportunities or whatever it is, products. But there were a lot of not so good stories behind the scenes. And with me looking at the opposite side, reading cases or, just paying attention to the lawsuits, there was a lot going on. I'm going to give you some examples. I'm not going to mention any of the athletes' names. It's public knowledge. You can absolutely find it. But why am I not mentioning the names? I just don't want to mention their names on the podcast, something that you can hear over and over again on here. That's more of a motherly instinct for me. I'm not going to call out these young students' names like that, but I will give you the facts, the details, because it's important for you to know, because we're not out of the clear and you still have to pay attention to some of these things, right? So I'm going to give you those facts. But if you want to know for yourself, then you can go dig and figure out who I'm talking about. But when you're looking at the collectives, when you're looking at these businesses and these organizations who were just jumping out there and offering these opportunities, there were a lot of athletes' lives that was getting turned upside down. There was one particular athlete who is a top tier quarterback. I'm not going to say was a top tier quarterback, definitely was considered a top tier quarterback recruit at that time. And that particular athlete filed a lawsuit against the University of Florida. Yes, I will mention the schools. They can take it. It is what it is, right? So at the University of Florida, they filed a lawsuit against the Florida Gators for NIL fraud. The lawsuit named the director of player engagement. It named the head coach and a major booster. And this particular athlete claimed that they orchestrated a scheme to flip his commitment from the University of Miami, who originally had offered 9.5 million to him. And what was Florida's offer to make him want to flip? Well, it was a staggering 13.85 million over 4 years, including a 1 million signing bonus. But that money never came. And that was an issue too. A lot of deals, a lot of offers were put out there, and there weren't a lot of people really bringing in the support they need to make sure it didn't just it escalated more from an offer to actually a binding contract. But in this case, he obviously felt it was, and sued because of it, because the money never came, and he made a decision, took action based on that decision. That particular quarterback ended up not going there. Obviously, didn't try to go back to Miami. Actually, I came here to Georgia. So he was betrayed before even stepping on the field. And you had another young man who was a star running back that was a lot of things being said around him, a lot of the offers being said, talked about, that he was offered, a lot of things that he received that was being talked about, that he received it because of, name, image, and likeness. And finally, this particular running back took to social media and wanted to clear the air. And he has stated, listen, they didn't buy me my house. I did. They didn't buy me my car. I did. And this $400,000 that I was told I was going to be getting, they didn't give me $400,000. I didn't even get $100,000 of that. And he has stated the collective lied about everything. And he wanted the people to know the truth behind the promises made broken. And it continues, not just males, not just football, right? It was happening to females as well. You had a particular female that attended the University of Florida and was, very popular at the University of Florida, and landed a modeling gig, right? Landing model opportunities, apparel opportunities, all types of opportunities. And right after this athlete finished second at the NCAA championships, she thought, wow, this stuff is coming in. I'm excited about it. I'm getting all these offers. These brands are jumping on me. It just seemed like a dream to her, right? Until it wasn't. And she was receiving checks that didn't clear, that bounced after she deposited them. And, just money's that's supposed to be paid out elsewhere wasn't being done either. And she felt that she was pretty much scammed. She was scammed. So those are just some 3 examples, right? There are a plethora more. We don't have the time to go through that. But if you do your research, which I implore you to do, now, of course, I may have a little more access to, some behind the scenes legal stuff, but there is plenty of information out there, enough at least for you to understand that you shouldn't go blindly into anything and understand what's going on. Or if you're on the other side, like maybe there's some individuals, right? Those sound like obviously bad intent, but there are some companies that not necessarily have bad intent. They just going with the flow, think they're doing the best thing. It's good for you to also study, read, so that you don't run afoul to what you think you're doing right is not. It's actually wrong. But there are a lot of contracts out there where these athletes have signed up to 40% commissions on things. They have bound themselves to postings or using their name, image, and likeness, which is fine. But what's not fine is there's no parameters to that. There's no expiration to that. Some of these contracts didn't speak to, yes, this contract is active while I'm representing, but what happens when you graduate, when you're no longer representing? Like, what happens? What is the start and end date? Is it in perpetuity? Is it forever? Is there boundaries on how it's actually used? Is it just for a particular product, or is it for your company to use it as you see fit? And a lot of these contracts didn't speak to that. There's intellectual property, which we call IP, intellectual property provisions that are not looked at. A lot of them are very templated. And so you're passing it from athlete to athlete to athlete. And a lot of these athletes, again, signing away a lot with no parameters at all and not bringing in legal advice. Now, you all who are agents and managers, this is no slight to you. Firstly, go back to the earlier segment. Like I said, you don't want to run afoul of the unauthorized practice of law. But even if you don't, even if there's something in there that you can actually speak of, sometimes legal advice will bring it to that next level because they have a keen eye. Even if you've been doing this for years, you're like, I've seen these contracts over and over and over and over again and been doing them for years. I think where there's a separation to at least get some type of legal advice is, one, we're trained on not just to look at, well, when I say we, very studious, competent, skilled attorneys, we're trained on not just looking at what's said, we're also trained on thinking about what's not said. But more importantly, those of us who are astute and stay up to date with cases, we're able to not even think out of the box, we're able to crush the box because we're seeing so many different things happen, so many different cases finding, or judges finding different ways on cases, and we can kind of look at each one or mix them together. So I still think it's important to bring legal advice, but everyone was just moving and they're just saying, hey, I just need a manager, I just need an agent. You need a team. If you're going to go big, you need a team to make sure that you are right. Now, having a team does not guarantee you, doesn't make it foolproof that things won't happen. That's in life general. That's in business transactions in general. That's in deals general. But what will happen is when you do all the things you're supposed to do and you have the team to make sure you do it, you make it so much more easier to have whatever that was supposed to be done enforced. And so when you hear about these athletes going to court, now you're spending money. You didn't even get money. You're spending money and you just don't know how the court is going to come down on that situation. And here's the thing about all of these contract deals, especially the ones that have ran afoul of the law. We probably won't be seeing the full effect of all that's not right. We probably won't see the full effect of that until about another 5 years, another 5 or 10 years, when you start to see things exposed, or you think it was this and it's something else, or something should have stopped. We won't see literally the full effect of the 2.0 exploitation. We just won't. And that's the part that is, that's the part that's troubling, but I'm sure it could be dealt with, and it will be dealt with, whatever that means. All right, so that brings us to right now, right? With all this stuff, all the chaos, while this was happening, the house was being built. You had the house settlement from the House versus NCAA. And this was a case that combined three cases together. With one case that was brought up, it was two other cases that was already going on, but made it a whole class action. And it was going on for years. It started like in 2020, but it continued to go, and it was finalized May 2025. It was finalized this year, and it actually went into effect July 1st. But this class action suit that was bought by, former and then current college athletes was about not just about getting paid for their name, image, and likeness while they play the sport. It was more about you owe us millions, millions and millions for when we didn't get paid. Listen, as a matter of fact, you're now saying that you concede to the fact that athletes can get paid for name, image, and likeness. What has changed now that was different than before? So we want back pay. We want our money. Show us our money. But more importantly, what about the lost opportunities I had? There were opportunities out there for me that I could have taken, and I lost those opportunities. Or there were opportunities that I did take and possibly was penalized for those. I think about Johnny Football, Reggie Bush. People had to do things under the table. So this case was more about, it's a landmark case. It's a big one. That's why I said it's the house. It's building everything. We got to put our furniture in there, but this is the house, from foundation framing to this house. That settlement, the plaintiffs are the people that's bringing the case to court. And the defendant side, the people that's fighting, which in this case was the NCAA, the Power Five schools, they defended this, right? They came together and decided we're going to come to meetings of mind. Instead of a judge deciding what the outcome is going to be, we're going to settle this and we're going to have conversations. And it took all these years between, fighting till they finally decided, okay, we're going to have to come up with something. We're going to converse. There was so many times that Justice Wilkins was like, okay, we're coming here. Nope, then it needs to be amended, going back and forth. And they landed on it. And they landed on a settlement that allowed over $2 billion, $2.57 billion to be paid in damages over a 10-year period. And then they laid out what this breakdown would actually look like. In addition to these billions of dollars being paid, what it would look like for a new revenue sharing framework, what it would look like for roster, like people being able to join, receiving direct pay from colleges. What does it look like as far as dealing with third parties, such as collectives? It looked at creating third-party enforcement agencies, such as the College Sports Commissioner and Deloitte, who will review contracts. So that's what all this looked like, right? And so this was huge. It went into effect, and they already said, okay, you have the defendants. The defendants are who's named in here, but there's people that weren't named in here. There's other Division I schools, not part of the Power Five. You weren't named in here, but you had an opportunity to opt in. You opt in. If you opt into this settlement, then you follow the guidelines based on this settlement, the guidelines that applies to the defendants in this settlement. And you will receive, the additional sports will receive the additional monies because they broke it down on how monies is going to be broken down, right? They're going to give $1.97 billion that's going to be paid out for broadcast, name, image, and likeness, video, name, image, and likeness, and lost opportunities for those Power Five athletes that played and attended between a certain time. And then they're going to give $600 million to additional sports. They're going to give to men and women's basketball that's not part of the Power Five, football that's not a part, and then additional sports. And so many issues right now have arisen already because of it. One, some schools decided We're going to opt in and we're going to adhere to this. And because of that, there's a contract. I'm hearing there's a contract that circulated, that was drafted, a draft contract that went out, and I believe it may be finalized already for these institutions to sign, because while this House settlement is out, there are still some state laws out there. There are still representatives that are pushing hard against this. And the NCAA want to make sure we're not sued by an institution for sure, for us enforcing this settlement between us. So there are those who opt in who have to sign things, sign a contract, and there's those who can decide to opt out. And if they opt out, then they can't, obviously they don't have to adhere to the stipulations of the settlement, but they also don't get the benefits um, of them either. So the two issues came immediately with the settlement that you should know if you're in this NIL space. Immediately, because they're not resolved yet. The first issue was a Title IX issue. When I just told you a minute ago, the additional monies, the $600 million that's going to be paid out. So you already have the broadcast, the video, lost opportunities. We already know if we're looking at broadcast and video, we're looking at specific sports. We just have to be honest with that. I mean, you got football, you got basketball, some things you just can't argue. But when you look at this additional monies, they're now even saying, okay, with the additional monies we paid out, then we're going to pay out 75% of that $600 million to football, the non-Power 5. We're going to pay 15% out to men's basketball, 5% out to women's basketball, and then the last 5% we're going to spread it amongst the other additional sports. And so the percentage, the distribution of that already raised issues, right? If 75% football, I understand there may be some kickers that have been women, but we know for the most part, football gonna be men. It's very clear. They said men's basketball, that's 15%. So do my math, that's 5, 5, 10 is 90% already? Men? And 5% to women's basketball, and the last 5% is additional sports. So that's other sports that may have men, not just women. So it was already a Title IX conversation. And then when they look at the revenue share that the schools are able to distribute, they're already saying that they feel like the schools are going to mirror the same distribution percentage of the $6 million that's being paid out. They feel it's going to go that way, right? If we can share up to 20+% of our revenue shares, we're going to share with football first. That's what we feel, bring it in. We're going to share with men's basketball if we have men's basketball, and then down. And so right now, immediately, that's what you're dealing with. So depends on who your athlete are, if you're dealing with men or women. That is a very, very, very huge thing. And then secondly, the second issue that immediately happened, and this was actually brought by the plaintiff's attorney, the people that brought the case, when it went into effect and NIL Go, Deloitte's system of checking these contracts, because they said we're going to check. If it's $600 or more, you got to submit these contracts for review. We're going to go back and check these contracts that were already established, and we're going to review them to make sure that they haven't run afoul of the law. Now, what did I just say when I started? I just said that most of those contracts, they already were paid for play. It very evident. And if I'm going to be honest, it's very hard not to be. But even if it's hard not to be, how you put it on paper makes the difference. What you put on paper is what gets you in trouble. And on paper, they said we're going to review. Make sure it's fair market value. Make sure it's not running afoul. And what did they do? They got a lot of contracts, and they were already going in on contracts. Say to canceling this, canceling that. Oh, it went crazy. And the plaintiff's attorney came in. It was like, wait, listen, we're breaching a settlement agreement already. And I think it was because not just so much the canceling of contracts, but there was no due diligence. There was no conversation. There was no inclusion on that. And so they stepped back, the defendants, they stepped back. And right now they're under a agreement that's in place right now, that's helping them right now. How it's going to unfold, not sure, but they did at least come up with something right now to say, let's put a break on just unraveling all of these contracts and let's figure this out together. So how that's going to unfold, you need to know that you in this NIL space, or you're going to enter in the NIL space, know that moving forward, you get a deal that's $600 or more, and that could be in kind, not just cash. It's going to be scrutinized. And the one thing that is very hard with that is their measurement of fair market value. What does that look like? Athlete to athlete, situations to situations. Who are they comparing who to? What are they comparing what to? So a lot of that already started happening. And so President Trump said, okay, he was already summoned several times. It was already written that there were individuals meeting, with President Trump over golf, all this. There was already conversations. Listen, we need you. We need federal lawmakers to step in because we don't see an end to this. Even with the House settlement, it's going to be a new issue because Justice Wilkins said that. She said, listen, I'm ruling only on the issue that's in front of me, which judges only can do. And whatever the settlement is, I'm here to make sure I enforce that. I'm not saying that there's not other lawsuits that can come out from this. And there were people waiting. She said, I'm not dealing with that now. You can wait. Once the finalized settlement comes out, go for it. And that's what happened. They went for it. So they were like, listen, President Trump, help. We need federal lawmakers to step into the situation. We need an attempt to create some type of national framework that can bring consistency, hopefully clarity with all of the chaos. And the SCORE Act was mentioned. It has not been enforced or, completely out there yet, but it is federal law that was introduced to protect what it's saying. It's supposed to protect, the NLI rights for student athletes. It will obviously make a uniform standard. And in that uniform standard, it would override state laws because when you're looking at federalism, if there are laws that govern state and laws that govern federal, and this governs in a particular area like interstate commerce, which this, if you read all the cases, that's what's brought up when we're talking about antitrust laws. The federal law would trump it. That's just in the supremacy clause. Like federal law is going to win. So it will bring uniformity. To be honest with you, I would like that. I would like that for several reasons. I would like federal law to bring uniformity. One, what that uniformity is, that's another question. But I would like to have some type of standardized understanding from state to state. And two, it helps attorneys because it would be federal law, would be federal practice. It helps attorneys to be able to help athletes in all different states. You don't have to just help them in the state in which you're licensed to practice. It's now federal, so you're licensed and you can practice federal law. So I would like it for those particular reasons to move forward. But the federal legislation is also talking about agent representation, legal representation, mandatory disclosures. It does mention addressing these collectives. It mentions a lot of different stuff, and it is also putting a charge. Hey, National Labor Relations Board, because we have this employer-employee argument. What are we going to do here? And it looks like they're looking at barring this employee classification. That's what it looks like legislation wants to do. That no, we want to bar that. We don't want that to happen. We want it to be still you student athlete, not employee. But we're pushing this. Let's finalize that because the NLRB, and someone mentioned this in our last segment, which they were absolutely correct, did look at cases. They look at Dartmouth, Northwestern. In one case, Northwestern's like, yeah, we actually do. If you look at the elements of employee-employer relationship, they're there. However, we don't have jurisdiction over this because you're a private school, but you're in a conference that have schools that are not private schools, and that's not our jurisdiction. Well, when Dartmouth came, it was like, okay, well, you're all private school. And they pretty much gave them a thumbs up. And they were looking at unionizing. So this federal legislation is going to have to speak to that, especially with what's going on right now. So I have a question here. Are there any athletes that are willing to share their experiences before the changes took place? And now are reaping the benefits of the change? We need more athletes too, but we don't know sometimes too in these contracts. We don't know what they're allowed to say or not say, allowed to share or not share when they're under a contract. So it depends on the contractual relationship and what they're actually bound to as far as confidentiality. But the one thing I do believe is there's going to be, when people are out and there's going to be a lot more stories that's going to be shared. And hopefully we can see from some of those who are reaping the benefits. And I'm going to talk about some of those who are actually reaping the benefits in segment 4. Deion Sanders' son. And yes, I know some people are going to say, oh, well, that's just Deion Sanders' son. But there's some other athletes I bring up in there that don't have a famous dad like Deion Sanders that are actually reaping the benefits. But I'm going to tell you why they're reaping the benefits. A little bit, I'm going to tell you why, because we're going to talk about it in the very last segment. They're reaping the benefits because they understood that now that I got this right in the marketplace, I understand that this is a business. I am a student athlete business person. And the ones I'm going to give the example showed I put the people around me to help me understand this and navigate this, because as an athlete, that's what I understood. And I love that people were, attracted to me to give me money, but I had the mindset that I really want to maximize this. And so the ones who are reaping the benefits of this NIL right are the ones who literally have the people around them to help them navigate it. And they look at it more than just getting some money right now for their name, image, and likeness. They look at it as a situation that sets them up beyond their sport. That's what the difference I'm seeing, and I'm not shocked by it. But I will talk about some of those athletes in the very last segment. I plan to mention those so I can give people guidance on some to-do actions on how to move forward in this, to not be scared. This information is for you to understand what not to do, and then you're gonna get some how-tos on how you should move forward. So right now, the legislation is stalled in Congress, and while it's stalled, they're like, "Listen, it's stalled. We don't want to keep arguing. This is crazy. Yes, these colleges have to sign these contracts so they can't sue, but it's nonstop." And so Trump decided to throw down an executive order, until they finalize, because that has to go through voting. We don't know if the legislation is going to pass, through House, Senate, everybody that it needs to go through. We don't know. I believe it did already make it through one step, but it may get stuck in this final step. And so until we know if this legislation will pass, Trump decided, okay, I'm going to come out and put out this executive order. And he's got an executive order called Saving College Sports. And it pretty much reinforces the things that I already talked about as far as the legislation. And that that's helping people somewhat, right? Because you have this executive order. But the reason why I said it's helping some people somewhat, and the reason why I kind of hesitated is because you have the lawmakers that's coming out fighting against this tooth and nail. They know, they understand federalism. They understand federal preemption. They understand that if this passes, the ones who are zealously protecting what they say the full right of the athlete, they understand for them the stakes are high with a federal preemption with the clauses that have been introduced. Um, they know that once that's there, there's certain things that they can't push against employer employee. The legislation and the executive order do talk about making sure we pay attention to those smaller sports. It is talking about making sure we pay attention to those women's sports. So it does mention that, but the state legislators feel that that's not enough and that the control will lean too far over, um, back outside of the athlete's hands. So I do want structure. I do want federal legislation. I do want it to be as fair as it can be. I do strongly agree that we need guardrails because we've seen what will happen when we're given something and we're not prepared. We end up worse off a lot of times, except for those ones who knew how to navigate it. They knew how to reap the benefit of it. But there was more of those who didn't than it was those who did. So I'm for it. What I just hope, though, is that when it's finalized and they go back and forth, it's something that doesn't just say we pretty much circled all the way back around. We're now giving you money, right? You're going to get this money, but it's still going to be under the way we say you can get it. So that's almost going all the way back around. We have this college sports commissioner, we have this entity reviewing contracts, and we have these arbitrary measurements, fair market value, when there's different type of factors that's hard to compare. So I hope we get it right. In the meantime, I want you to know how to get it right specifically by the information I just gave you. So to wrap it up, get it right by knowing the key cases that I just talked to you about. So that way you show up in rooms competent and sure. You're able to educate your athletes. If you're an athlete, you are educated and you can show up confident and sure. There's nothing better than the athlete, the person who is entering the deal, showing up oozing readiness. That helps before we even open up our mouths to negotiate contracts. I promise you, all these little things matter. So understand that. Understand that it's not as chaotic, but it's still some chaos there because there's still some things that have to be, even in the settlement, have to be put in place. And they have to make sure, when I say they, the parties to the contract, those schools that opt in, also make sure that they're not running afoul of the settlement. We still got to pay attention, have deep, deep, deep conversations with women that are playing in these sports, running in these sports, have deep conversations. We have to think out of the box or crush the box when it comes to the type of deals. So these are the things that's going to help position you. Really pay attention to those things and pay attention to the executive order that's out right now. Get familiar with what the legislation's proposed legislation is. We don't know how it'll end up landing. Just be familiar with that. But know what the executive order is saying right now and know why the states are pushing back. Hear why they're pushing back. Knowing that information will also help you into identifying and going into deals as well. It's not just about law, it's about being informed so you know how to actually, you know, actually move in the rooms. You said it's almost like defeating all that was gained if you were not prepared. That it is. It's not even almost. It is. It is. If you're not prepared, as the statement just said, if you're not prepared for the right that you want to get from the fight, it's almost like you lost, right? Or you did lose, at least temporarily. So we have to, if we weren't prepared, we have to now be informed and do what we need to do with that information to be prepared on how to move forward. Because this is a continual moving train, which is a good thing. It didn't stop, and it's a continual moving train. You now can be informed and get prepared. So that way you are operating at the highest level, no matter who your client is. You're operating at the highest level, or if you are the client. The more we all prepare, the better. But more importantly, the student athletes, this is a great opportunity for you to change generations, change your legacy. You don't want to have an opportunity that is short lived, and everyone's throwing out these little temporary opportunities. How can you make that a bigger situation? All right, that is it for today. I did good. Listen, so far I'm hitting my goal. I did good. All three segments. I'm gonna keep that momentum for because this is a topic that I hope you can also hear just from my delivery. I'm very passionate about because it's a topic I'm passionate about, and because it is a very dense, complex topic. This can go on and on. But I committed to and did my due diligence in bringing it to you in under an hour. That has been my goal. And bringing to you exactly what you need to know to start now. Again, for yourself, for someone you're supporting now or in the future. Because remember, this is what the kids are going to grow up in. I was just on an AI panel. We're talking about artificial intelligence. I'm not going to say 2.0. Where we at? 5.0, 6.0? A large language model. These are where kids are growing up. You grow up in this stuff. And so they're going to grow up into this. And you have to understand the ins and out in this too, just by choosing the sports. If they multi-talented different sports, this help with a lot of decision making. When you talk about the NIL, when you're looking at the school, you're looking at academics, and you're looking at this, there's a lot of different things that you need to look at and understand in order to look at it better. So yeah, that's where we stand right now with the House settlement in effect and third-party enforcement agencies that have been established with the NCA framework. And those third-party enforcement, again, Deloitte, who review contracts, the College Sports Commissioner, who enforces these rules. And we're at the brink of possible federal legislation. We do have an executive order in place to bind how the House settlement, is applied. And so in our final segment, we're going to shift from the policies and the power that's shifting from the policies to actually execution ownership. And like I stated earlier, I will give examples on that. Just like we have some not so good, we have plenty models of so good that we can talk about. And I will talk about that. So going from this information to executing into owning better, and what these rules may possibly mean. Let us forward think what we need to be accountable for, how to protect athletes in real time, knowing all that through foresight. How can we do it? So we're going to shift our segment conversation now, going from surviving NIL to thriving in NIL, and hopefully building systems that last beyond the sport, the game. All right. So I leave you with this quote: access creates opportunity, but competence turns it into ownership. You ask for the access, but now you need the competence. Thank you for tuning in and engaging. Thank you for adding value, Ms. Vonda. Thank you so much. If anybody has any questions and you were not able to attend live, again, please put the comments in your question in the comments. Do not seek me out and find me and email me. I will not respond to any personal emails. I, again, am not giving personal legal advice, but if you want to engage in a conversation, please feel free to add your comment here. And also, they drop on the podcast each segment before the next Tuesday segment drops. So, segments 1 and 2 are now available on all major streaming podcast platforms. So wherever your favorite place of listening to a podcast, you can listen to it there. You can sit, you can walk, you can drive, you can clean, you can get this in your system, get it in your bones, and really understand it. Because remember, the more you know, the more you grow. The more you learn, the more you can earn. And in this case, the more your athlete can too. But when you share, you show care. So don't keep this knowledge to yourself. Please, especially this. I say that all the time. Hey, I can't help it. We talk about great things. Spread the wisdom, tag a friend, and let's elevate together. Until next time, keep striving, keep growing, and most importantly, keep seeking elevation, peace, and progress.